shall consist of 7 members appointed by the governor by and with the advice and consent of the Senate. 5 members having been confirmed by the New York State Senate affords the Commission an ability to establish a quorum and undertake action. This present meeting of the Commission is now called to order. Ms. Secretary, will you please call the roll?
John Crotty.
Here.
John Peter Machete.
Here.
John Baklemba.
Here.
Barry Sample.
Here.
Todd Snyder.
Here.
Ms. Secretary, please have the record reflect that a quorum of qualified members are present, thus enabling the transaction of business. Given the absence of a designated chair, would the members like to select a member for the purposes of presiding over today's meeting?
I would like to nominate Todd Schneider.
Second.
Very popular.
A moment of great consensus. Minutes of the Commission meetings conducted on November 23rd, 2015 have been provided to the members in advance. At this time, I'd like to ask the members if there are any edits, corrections, or amendments. Hearing none, Madam Secretary, please let the record reflect that the minutes were accepted. We start the agenda with rulemaking. New York Statute Racing Parimutuel Wagering and Breeding Law, Section 104.19 authorizes the Commission to promulgate rules and regulations that it deems necessary to carry out its responsibilities. In that regard, the Commission will, from time to time, promulgate rules and rule amendments pursuant to the State Administrative Procedure Act. We have 2 items for consideration today. Rob, would you mind outlining the first item?
Certainly. As item 3A for Commission consideration is adoption of a proposed regulation regarding altering the sex of a horse for harness and thoroughbred. This proposal would require that any alteration to the sex of a horse from that recorded on the certificate of full registration, eligibility certificate, or other official registration certificate be reported to both the racing secretary and the official horse identifier if the horse is entered to race at any race meeting. As you may recollect, the genesis of this proposal was founded in concerns raised by the wagering public about the absence of any rule or procedure which required the timely reporting of first-time geldings in races. As it is generally accepted wisdom that first-time geldings are likely to run better than they ran before they were gelded, timely information on first-time geldings would be helpful to handicappers. California, Oklahoma, and Texas all have similar rules. The public comment period for this rule proposal expires at the close of business today. To date, only 1 public comment has been received. Batavia Downs has written that they are strongly in favor of this proposal. Staff recommends adoption of this rule, subject to no substantive comment being received by the close of business today.
Are there any questions on the adoption of the gelding reporting requirements from the commissioners? May I have a motion to adopt this rule?
So moved to adopt.
A second?
Second.
Any discussion on the motion? All in favor?
Aye.
Aye.
Any opposed? The motion carries. Rob, would you call the next? Sorry.
At the track?
Because of the rule adoption or the rule proposal that we had, some tracks are actually conforming to it on an early basis. This now requires that action to occur and not leave it as the discretion of each racetrack.
Okay.
Rob, the next item?
Certainly, as item 3B for the Commission's consideration is adoption of emergency rulemaking and proposed rulemaking for Jockey Injury Compensation Fund assessments and plan for 2016. The Jockey Injury Compensation Fund is a statutorily created not-for-profit corporation charged with securing workers' compensation insurance for the benefit of all jockeys, apprentice jockeys, and exercise persons licensed to participate in New York thoroughbred racing. In order for JICF to pay costs of workers' compensation insurance that the law requires, and to carry out its duties under the New York workers' compensation law, JICF shall ascertain the total funding necessary and establish the sums that are to be paid by all owners and trainers licensed or required to be licensed to obtain the total funding amount required annually. The statute requires JICF to submit to the Commission no later than November 15th of each year an annual amendment of its plan of operation relating to the assessment of costs of insurance for the subsequent year. The Commission then reviews and, if appropriate, approves the plan. The statutory deadline was not met this year. Instead, the JICF wrote to the Commission on November 16th asserting that the JICF was not able to submit a written plan that is fair, equitable, and in the best interest of racing by the statutory deadline. Upon information and belief, the JICF had sought to secure insurance in the private markets. This is the second consecutive year that JICF did not meet the statutory deadline for submitting a plan. In 2015, JICF was provided additional time to seek quotes from a private insurer. The JICF was unable to secure a private policy and thus eventually submitted a plan with coverage from the State Insurance Fund that the Commission approved. The law specifically contemplates the failure of the JICF to submit an adequate plan. The law provides that in the absence of an approved plan, the Commission shall adopt and promulgate such reasonable rules as are necessary or advisable to effectuate the law. Staff believes that it is prudent to have a standing default provision set forth in Commission rules. Thus, for Commission consideration, are emergency rules and proposed new rules that would set forth general plans for JICF assessments to fund insurance premiums for 2016 and other related matters. An emergency rulemaking would be required to ensure that workers' compensation coverage remained in place uninterrupted. To the knowledge of the Commission staff, the only current workers' compensation insurance quotation for the JICF for 2016 has been quoted by the New York State Insurance Fund. Staff utilized this quote to establish rates for the proposed 2016 plan. The staff proposal bases assessments on a combination of PERS assessments, per-day stall fees, and per-claim assessments to account for the State Insurance Fund premium cost and to incentivize trainers and owners to control claims. We believe this to be fair, equitable, and in the best interest of racing. If adopted as an emergency rule, the 2016 assessments would remain effective for the year or by statute until such time as the JICF submits a superseding plan approved by the Commission. And this morning, the Jockey Insurance Compensation Fund filed with the Commission a proposed plan and assessment for 2016. The proposed JICF plan is markedly different in cost structure than that being considered in our rulemaking and will, if approved, maintain the rates imposed by the JICF in its 2015 plan. Staff will commence reviewing their proposal this afternoon or tomorrow morning. If approved, as I mentioned, it would supplant the actions being considered here today. Regardless, the staff recommends the proposal of these emergency and proposed rules.
The governing statute, Racing Law, Section 221(8)B, provides that the Commission shall, after notice and hearing, adopt and promulgate such reasonable rules as are necessary or advisable to effectuate the statutory provisions. The Commission specifically provided notice to the Chairman and outside counsel of the Jockey Injury Compensation Fund. Is there anyone from the JICF who would like to be heard here today?
Their outside counsel suggested that the conversations that I've had with him this morning relative to the plan that they submitted would suffice for their comment.
Very good. Commissioners, any discussion? I think we should take the emergency rulemaking first and then the proposed rulemaking after that. If there are any questions about the emergency rulemaking for the JICF assessments and plan for 2016 at this time? If not, may I have a motion to adopt the emergency rules?
So moved.
Second?
Second.
Any discussion on the motion? All in favor?
Aye.
Any opposed? The motion carries. Are there any questions regarding the rulemaking for the proposed, are there any questions regarding the proposed rulemaking as opposed to the emergency rulemaking? May I have a motion on the proposed rulemaking?
So moved.
Second?
Second.
Any discussion? All in favor?
Aye.
Any opposed? The motion carries. The next item on the agenda regards adjudications. The Commission has 4 hearing officer reports. Three. Thank you. Sorry. 3. 3 hearing officer reports for consideration today. Mr. Williams, would you mind outlining the first case?
Certainly. First case is in the matter of Kevin Clark. On June 11, 2015, the Bureau of Licensing declined to license Kevin Clark as a stable employee. The denial was based on a violation of a Commission rule against drug use on track grounds while Mr. Clark's application was pending. Specifically, Mr. Clark tested positive for marijuana metabolites. After Mr. Clark appealed, a hearing was conducted on July 23, 2015, at which Mr. Clark failed to appear. The hearing officer's report and recommendation were delivered to the Commission Secretary on November 17, 2015. The hearing officer recommended that the license denial be upheld on the grounds of a violation of the rule against drug use and the applicant's criminal history. This matter is now ready for final agency determination. At a meeting conducted pursuant to the judicial or quasi-judicial proceedings exemption of the New York Public Officers Law, Section 108.1, the Commission considered this matter.
The Commission duly deliberated and considered this matter and determined upon a 5-0 vote to sustain the hearing officer's report and recommendations. Mr. Williams, the next matter.
In the matter of Victor Valderrama, on August 5, 2015, the Bureau of Licensing declined to issue a license to Victor Valderrama as a stable employee. The denial was based on the conclusion that his experience, character, and general fitness are such that the participation of him would be inconsistent with the public interest, convenience, or necessity, and with the best interest of racing generally. Specifically, Mr. Valderrama had failed to disclose criminal convictions on his license application and failed to disclose to the Commission an arrest subsequent to the filing of his application. After Mr. Valderrama appealed, a hearing was conducted on September 17th. The hearing officer's report and recommendations were delivered to the Commission Secretary on November 18th. The hearing officer recommended that the license denial be upheld. This matter is now ready for final agency determination.
The Commission duly deliberated and considered this matter and determined upon a 5-0 vote to sustain the hearing officer's report and recommendations. In the matter of delight distribution?
On July 28, 2015, the Bureau of Licensing issued a notice of license suspension of the lottery sales agent license of Delight Distribution, which is located at 3768 74th Street in Jackson Heights, Queens. The notice informed Delight Distribution that the suspension was for failure to comply with Commission instructions regarding to licensed activity and for fraud, deceit, misrepresentation, or conduct prejudicial to the confidence in the state lottery, in that the licensee misrepresented ownership. An August 12, 2015 amendment to the notice of license suspension added as a grounds for suspension failure to remit funds owed to the lottery. The notice stated that the suspension would become a revocation unless Delight Distribution requested a hearing. After request by Delight Distribution, a hearing was conducted on October 1st. The hearing officer submitted a report to the Commission Secretary on November 18th. The hearing officer recommended that the license be revoked and that the suspension of the license until revocation be upheld on the grounds that the sales agent falsified ownership of the licensee, thereby engaged in conduct that was fraudulent, deceitful, and undermined public confidence in the lottery. This matter is now ready for final agency determination.
The Commission duly deliberated and considered this matter and determined upon a 5-0 vote to sustain the hearing officer's report and recommendation. I think we can move on to...
Mr. Chairman,
yes.
I think we had some questions regarding the issuance of this license to begin with, and
Yes.
that staff was going to talk to the district director to determine the procedures for the initial issuance here.
Right. Is that right, Rob?
I will certainly do that, yes.
Excellent. Thanks, John. Consideration of gaming facility licenses. Given the level of interest in the casino licensing process, I think it is appropriate to start this portion of our agenda with a plain language overview on what the law requires regarding the commercial casino licensing process, and more importantly, what the law does not allow. Ed, could we ask you to please provide us with a plain language overview?
I will. I'd like to take a moment to describe for you and for the public what your statutory duties are in regard to licensing gaming facilities pursuant to Article 13 of the Racing, Parimutuel Wagering, and Breeding Law. It would also be useful, I think, to clarify what is not your role or responsibility in regard to these licensing decisions. Misperceptions abound among some casino opponents, some public officials, and some in the media in regard to what your role is today in considering these decisions. The legislature established a two-layered process for the consideration of potential casino gaming facilities in New York State. You appointed a gaming facility location board in 2014, as the law required you to do. The Gaming Facility Location Board, in a competitive process, received 17 applications in 2014 in 3 statutorily defined upstate regions for casino gaming facilities. Those regions were the Catskill-Hudson Valley region, the Capital region, and the Eastern Southern Tier region. The Gaming Facility Location Board deemed 16 of those applications responsive and applied statutory evaluation criteria to select 3 applicants for your consideration for licensure. It is important to note that your role is not to reevaluate all of the applications, compare applicants, or to consider or reconsider the selection criteria the Gaming Facility Location Board considered and applied. Your role is not to substitute your judgment for that of the Gaming Facility Location Board. Your role is not to decide whether you think the Gaming Facility Location Board made the correct selections. Your role is not to exercise any review of the selection decisions the Gaming Facility Location Board made. You may or may not have different views of which applicants the Gaming Facility Location Board should have selected. That is of no matter, because the law did not give to this commission the authority to select applicants for gaming facility licensure consideration. The law gave the Gaming Facility Location Board the sole power and authority to make those selections. You are not an appellate body exercising review of the Gaming Facility Location Board's processes or decision-making. Rather, your charge is to consider only the applicants that the Gaming Facility Location Board selected and presented to you. With respect to each of those applicants, the legislature has charged you with determining whether each applicant is qualified for licensure, is not disqualified for licensure, and has met statutory minimum qualifications for licensure. If you conclude that those criteria are present for an applicant, you have the power to grant a gaming facility license to such applicant. I would like to review now with you those statutory criteria. Before issuing a gaming facility license to an applicant, the Commission must determine that the applicant is suitable for licensure and not disqualified, as set forth in sections 1317 and 1318 of the New York State Racing, Parimutuel Wagering, and Breeding Law. These sections require the Commission to consider an applicant's overall reputation, which includes, without limitation, integrity, honesty, good character and reputation, financial stability, integrity, and background, business practices and business ability to establish and maintain a successful gaming facility, compliance with gaming licensing requirements in other jurisdictions, involvement in litigation regarding business practices, suitability of affiliates, close associates, and financial resources, and disqualifying criteria. The law hinges suitability on and directs the Commission to review whether an applicant or any individual associated with an applicant was convicted of a felony or other crime involving public integrity, embezzlement, theft, fraud, or perjury, committed prior acts that form a pattern of misconduct, has affiliates or close affiliates that would not qualify for a license, or whose relationship with the applicant poses injurious threat to the interest of the state, has pursued economic gain in an occupational manner that is in violation of criminal or civil public policy, is identified as a career offender or member of a career offender cartel, has flagrantly defied any legislative or other investigatory body engaged in the investigation of crimes related to gaming, official corruption, or organized crime activity, or has failed to make required child support payments, repay public assistance benefit overpayments, or repay any other debt owed to the state. Once the Commission determines that an applicant is suitable and not disqualified, the Commission must then review the applicant's entire application and evaluate whether the applicant meets the minimum license thresholds set forth in Section 1316 of the New York State Racing, Parimutuel Wagering, and Breeding Law. This statute requires that no applicant shall be eligible to receive a gaming license unless the applicant meets the following criteria and clearly states as part of an application that the applicant shall, 1, in accordance with the design plans submitted with the licensee's application to the board, invest not less than the required capital under Article 13 into the gaming facility. 2, the applicant shall own or acquire within 60 days after a license has been awarded the land where the gaming facility is proposed to be constructed, provided, however, that ownership of the land shall include a tenancy for a term of years under a lease that extends not less than 60 years beyond the term of the gaming license issued under Article 13. The applicant shall, 3, meet the license deposit requirement. The applicant shall, 4, demonstrate that it is able to pay and shall commit to paying the gaming licensing fee. The applicant shall, 5, demonstrate to the Commission how the applicant proposes to address problem gambling concerns, workforce development and community development, and host and nearby municipality impact and mitigation issues. The applicant shall, 6, identify the infrastructure costs to the host municipality incurred in direct relation to the construction and operation of a gaming facility and commit to a community mitigation plan for the host municipality. The applicant shall, 7, identify the service costs of the host municipality incurred for emergency services in direct relation to the operation of a gaming facility and commit to a community mitigation plan for the host municipality. The applicant shall, 8, pay to the Commission an application fee of $1 million to defray the costs associated with the processing of the application and investigation of the applicant, provided, however, that if the costs of the investigation exceed the initial application fee, the applicant shall pay the additional amount to the Commission within 30 days after notification of insufficient fees, or the application shall be rejected, and further provided that should the cost of such investigation not exceed the fee remitted, any unexpended portion shall be returned to the applicant. The applicant shall, 9, comply with state building and fire prevention codes, and the applicant, 10, shall formulate for board approval and abide by an affirmative action program of equal opportunity, whereby the applicant establishes specific goals for the utilization of minorities, women, and veterans on construction jobs. Additionally, the Commission cannot award a license to an applicant until the Commission, as an involved agency, has complied with the State Environmental Quality Review Act. SECRA requires that the Commission adopt the lead agency's findings or make its own findings with respect to an applicant's environmental impact statement, if one has been issued. If the lead agency has issued a negative declaration, there are no findings the Commission is required to make in regard to SECRA.
Thanks, Ed. Mr. Williams, will you please call the first application for consideration?
Certainly. The first application for consideration is Capital Region Gaming, LLC, doing business as Rivers Casino and Resort at Mohawk Harbor. Each commissioner has been provided with a copy of Capital Region's response to the Gaming Facility Location Board's request for applications to develop and operate a gaming facility in New York State, a matrix of proposed changes or amendments to their submission post-February 27, 2015, a summary of the New York State Police investigative report regarding the applicant, its affiliated companies and principal management personnel, and 2 supplemental memoranda, a memorandum identifying minimum licensing threshold requirements, a license form with conditions specific to the applicant and their proposal, and an involved agency State Environmental Quality Review Act statement of findings for gaming facility license applicant, Capital Region Gaming, LLC.
Commissioners, may I have a motion to find Capital Region Gaming, LLC, doing business as Rivers Casino and Resort at Mohawk Harbor, suitable for gaming facility licensing per standards contained within sections 1317 and 1318 of the New York State Racing, Parimutuel Wagering, and Breeding Law?
I so move.
A second?
Second.
Any discussion on the motion? All in favor?
Aye.
Any opposed? The motion carries. Commissioners, may I have a motion to find the application as amended, submitted by Capital Region Gaming LLC, doing business as Rivers Casino and Resort at Mohawk Harbor, as meeting the minimum licensing threshold set forth in Section 1316 of the New York State Racing, Parimutuel Wagering, and Breeding Law?
I so move.
Second.
Any discussion on the motion? All in favor?
Aye.
Aye.
Any opposed? The motion carries. May I have a motion to adopt the lead agency's secra findings statement certifying that the requirements of Title VI, New York Code Rules and Regulations, Part 617, have been met and consistent with social, economic, and other essential considerations from among the reasonable alternatives available. The action is one that avoids or minimizes adverse environmental impacts to the maximum extent practicable. May I have such a motion?
So move.
Second.
Any discussion on the motion? All in favor?
Aye.
Any opposed? The motion carries. Commissioners, may I have a motion to execute the Gaming Facility License Award for Capital Region Gaming LLC, doing business as Rivers Casino and Resort at Mohawk Harbor, pursuant to Section 1311 of the New York State Racing, Parimutuel Wagering, and Breeding Law?
I so move.
Second.
Any discussion on the motion? All in favor?
Aye.
Aye.
Any opposed? The motion carries. Mr. Williams, the next applicant.
The second application for consideration is Lago Resort and Casino LLC, doing business as Lago Resort and Casino. Each commissioner has been provided a copy of Lago Resort and Casino LLC's response to the Gaming Facility Location Board's request for applications to develop and operate a gaming facility in New York State, a matrix of proposed changes or amendments to their submission post February 27, 2015, a summary of the New York State Police investigative report regarding the applicant, its affiliated companies and principal management personnel, and 2 supplemental memoranda, a memorandum identifying minimum licensing threshold requirements, and a license form with conditions specific to the applicant and their proposal. No lead agency secret findings statement was circulated because the lead agency issued a negative declaration. A negative declaration is a determination by the lead agency that an action will not result in significant and adverse environmental impact, and consequently, no environmental impact statement was prepared.
Commissioners, may I have a motion to find Lago Resort and Casino LLC, doing business as Lago Resort and Casino, suitable for gaming facility licensing per standards contained in Sections 1317 and 1318 of the New York State Racing, Parimutuel Wagering, and Breeding Law?
So moved.
Second?
Second.
Any discussion on the motion? All in favor, say aye.
Aye.
Any opposed? The motion carries. May I have a motion to find the application as amended, submitted by Lago Resort and Casino LLC, doing business as Lago Resort and Casino, meets the minimum licensing threshold set forth in Section 1316 of the New York State Racing, Parimutuel Wagering, and Breeding Law? May I have such a motion?
So move.
Second?
Second.
Any discussion on that motion? All in favor?
Aye.
Any opposed? The motion carries. May I have a motion to execute the Gaming Facility License Award for Lago Resort and Casino LLC, doing business as Lago Resort and Casino, pursuant to Section 1311?
So moved.
Second.
Any discussion? All in favor?
Aye.
Aye.
Any opposed? That motion carries. Rob, would you mind calling the next applicant?
Certainly. The final application for consideration is Montrain Operating Company LLC, doing business as Montrain Resort Casino. Each commissioner has been provided with a copy of Montrain Operating Company LLC's response to the Gaming Facility Location Board's request for applications to develop and operate a gaming facility in New York State, a matrix of proposed changes or amendments to their submission post February 27, 2015, a summary of the New York State Police investigative report regarding the applicant, its affiliated companies and principal management personnel, and 2 supplemental memoranda, a memorandum identifying minimum license threshold requirements, a license form with conditions specific to the applicant and their proposal, and an involved agency's involved agencies State Environmental Quality Review Act Statement of Findings for Gaming Facility License Applicant Montrain Operating Company, LLC.
Commissioners, may I have a motion to find Montrain Operating Company, LLC, doing business as Montrain Resort Casino, suitable for gaming facility licensing per standards contained in sections 1317 and 1318 of the New York State Racing, Parimutuel Wagering, and Breeding Law.
So moved.
May I have a second?
Second.
Any discussion on the motion? All in favor?
Aye.
Any opposed? The motion carries. May I have a motion to find the application as amended submitted by Montrain Operating Company, LLC, doing business as Montrain Resort Casino, meets the minimum licensing threshold set forth in Section 1316 of the New York State Racing, Parimutuel Wagering, and Breeding Law? May I have such a motion?
So moved.
Second.
Any discussion on that motion? All in favor?
Aye.
Any opposed? That motion carries. May I have a motion to adopt the lead agency's SECRA findings statement certifying that the requirements of Title VI of the New York Codes, Rules, and Regulations, Part 617, have been met and consistent with social, economic, and other essential considerations. From among the reasonable alternatives available, the action is one that avoids or minimizes adverse environmental impacts to the maximum extent practicable. May I have such a motion?
So moved. Second.
Any discussion on the motion? All in favor?
Aye.
Any opposed? The motion carries. Commissioners, may I have a motion to execute the gaming facility license award for Montrain Operating Company, LLC, doing business as Montrain Resort Casino, pursuant to Section 1311?
So moved. Second.
Any discussion on the motion? All in favor?
Aye.
Any opposed? The motion carries. The next item on the agenda is old business. I note there are 2 items. Mr. Williams, would you present the first item?
Certainly. Last month, the staff issued a report in regard to allegations advanced by the People for the Ethical Treatment of Animals in regard to the practices of KDE Equine LLC et al. At the conclusion of the meeting, staff requested that the rule drafts contained within the report be released to receive public comment in advance of rulemaking consideration. While we have received some comments anecdotally, staff requests an additional month to specifically contact those entities that are likely to be affected or have concerns with the various proposals. I would suggest that any substantive comments regarding the report or proposals be withheld until the conclusion of next month's meeting, or at next month's meeting.
I think it's fine, unless the commissioners feel otherwise, to defer discussion.
You were going to have Dr. Palmer here.
Yeah,
So
Dr. Palmer will be here at the January meeting.
we can ask him some questions, and maybe he can give us some answers.
Thank you.
Rob, the next item?
Also last month, commissioners requested staff conduct research into the use of the whip or crop in jurisdictions across the United States. I want to thank the National Jockeys Guild for providing information relative to crop use and identifying how different jurisdictions are now considering its use. I'm also aware that Ed staff has been undertaking research in this and expects to soon be circulating a memorandum relative to this research, but the research is not yet complete.
You did circulate something, though, didn't you?
I might have circulated the materials that the Jockey Club provided,
Yeah,
or
we
I mean,
saw-
the
yeah,
Jockey
we got
Guild
some
provided.
preliminary information.
Oh, okay.
So when do you think, in a month or so?
Oh, yeah, before the next meeting, for sure.
Great.
Commissioners, are there any other old business to consider? We have no items scheduled under new business. Does anyone have any other new business to consider? Hearing none, I think Kristen is going to work on scheduling.
26th.
January
I think
26th.
We're
we
looking at the
talked about
26th.
26th. Everybody is good. You're good for the
Yeah.
26th? Yeah.
Okay.
Thank you.
Tuesday.
That concludes today's published agenda. Do any commissioners have items they'd like to present for consideration? Mr. Crotty? Mr. Crotty, do you have other items you'd like to present?
I would like everyone to have a happy and safe holiday.
Indeed,
Very nice.
indeed.
So
We
glad
are
we got together
adjourned.
right
Happy
before.
holidays, everyone.
Nice job.
Happy holidays.
Lisa's here.